Hi, welcome to NYAY PATHSALA. Today's topic is Doctrine of Res Gestae. Section 60 of the Indian Evidence Act says that oral evidence to be admissible, it must be direct. The concept of Doctrine of Res Gestae is an exception to the hearsay rule. Black Law Dictionary defines res gestae as follows. It is a Latin expression which means things done or accomplished. In other words, in legal parlance, hearsay evidence is no evidence. So let us understand what is Section 6 of the Indian Evidence Act. The principle of law as embodied in Section 6 of the Indian Evidence Act is usually known as the rule of res gestae. Section 16 of the Indian Evidence Act 1872 reads as follows. Relevancy of facts forming part of same transaction. Facts which, though not in issue, are so connected with a fact in issue as to form part of the same transaction are relevant, whether they occurred at the same time and place or at different times and places. The most important part of this section is that this section uses the words same transaction. You pause at section 6 and look into that word same transaction. The word same transaction occurs in section 220 and 223 of this CRPC also, but in that section it is in a restricted sense and also as an illustration A of section 6. But the word transaction is used in a more general sense in section 6. We should look into some of the illustrations set out under section 6 of the Indian Evidence Act. Whenever we read a barrack and whenever we read the section, it is always essential to look into the illustration because illustrations gives a clear concept as what the section means. Let us look into the first illustration of section 6. This is A. In this illustration, it goes like this. A is accused of the murder of B by beating him. Whatever was said or done by A or B or the bystanders at the beating or so shortly before or after that it has to form part of the transaction is a relevant fact, because from section 5 to section 55 of the Indian Evidence Act which talks about the relevancy of fact. The second illustration is that A is accused of waging war against the government of India by taking part in an armed insurrection in which property is destroyed, troops are attacked and goals are broken open. The occurrence of this fact is relevant as forming part of the general transaction, though A may not have been present at all of them. Say for example, a banned extremist group takes part in all kinds of destructive activities. The commander may not be present in all the places. If you can show that it relates to part of the same transaction, then it can be shown to be applicable under section 6 under the heading same transaction. The third illustration is say A sues B for a libel contained in a letter forming part of a correspondence. This is especially in case of defamation. So letters between the parties relating to the subject out of which the libel arose and forming part of the correspondence in which it is contained are relevant facts, though they do not contain the libel itself. The fourth illustration is the question is whether certain goods ordered from B were delivered to A. The goods were delivered to several intermediate persons successively. Then each delivery is a relevant fact. The doctrine of res gestae comprises facts that form part of the same transaction. So it is relevant to examine, number 1, what is a transaction? Number 2, when does it start? Number 3, when does it come to an end? If any fact isn't able to form a link of itself with the main transaction, it doesn't pass the test of being a res gestae and hence become inadmissible. As I have already told before that section 6 is an exception to the rule of evidence hearsay evidence is not admissible. So what is the test of applying the rule of res gestae? The test for applying the rule of res gestae is that statement or fact should be spontaneous, number one, and it should form part of the same transaction, ruling out any possibility of concoction. So we should remember the first rule is that it should be the statement should be spontaneous, it should form part of the same transaction, and it should rule out any possibility of concoction. The purpose of incorporating Section 6 in Evidence Act is to complete the missing links in chain of evidence of solitary witness. But for bringing such hearsay evidence within ambit of Section 6, we must remember that it must be almost contemporaneous with the acts, and there should not be an interval which should allow fabrication or concoction. Statements which are said to be admitted as forming part of res gestae must always be made contemporaneously with the act or immediately thereafter. The test to determine admissibility of evidence under the rule of res gestae is embodied in the words "are so connected with a fact in issue as to form part of the same transaction." It is therefore that for describing the concept of res gestae, one would need to examine whether the fact is such as can be described by use of the words or phrases such as, number one, contemporaneously arising out of the occurrence, number two, exclamation of heart, number three, seeking help of disbelief, of cautioning and the like, number four, arising out of the fact, spontaneous reaction to a fact and the like. As pointed out by Sarkar in his book on evidence, the facts which are relevant to the issue of res gestae have been arranged in the Act from Section 6 to 55 of the Indian Evidence Act. In Sarkar's evidence book on evidence, from Section 6 to 16, it talks that things connected with the facts in issue as part of the same transaction, occasion, cause, effect, motive, conduct, etc. Section 17 to 31 of the Evidence Act talks about things said about it, namely admissions and confessions. When we talk about admissions and confessions, when you talk about 17 and 31, admission also includes confessions, but confession may not include admissions. Number 3 is from Section 32 of the 33 of the Evidence Act. It talks about statement by persons who cannot be called as witnesses. Likewise, from Section 34 to 39, it talks about statements under special circumstances. Number 5, things decreed in courts, namely judgment in other cases. This is dealt with Section 40 and 44 of the Evidence Act. And the number 6, Sarkar talks about opinions, which is dealt with under Section 45 and 51 of the Evidence Act. And number 7 is character and reputation of parties concerned, which is very important in the Indian Evidence Act, which we'll be dealing with each of these parts separately. But today I am just going through the sections. This character and reputation of the parties concerned, say for example, is dealt under Section 52 and 55 of the Evidence Act. We'll be dealing with this Sarkar's individual analysis of the sections in the coming videos of NYAY PATHSALA. But today we will concern ourselves to the doctrine of res gestae only. As I have already stated that the provisions of Section 6 of the Indian Evidence Act deals with an exception to the rule of hearsay evidence. The provisions of the Section 6 of the Indian Evidence Act have been sufficiently explained in the judicial decisions of the Honorable Supreme Court. Because at this stage we should remember that the Indian Evidence Act 1872 is a consolidated act. To understand many of this section, we have to look into the judgments of the Honorable Supreme Court, because precedent is binding on all the lower courts. That means any judgment or order passed by the Supreme Court is binding on the courts below. The first reported case on the doctrine of res gestae is, you may kindly note it down, or you may pause the video at this stage to look into that citation. It is Jentela Vijayvardhan Rao versus State of Andhra Pradesh, reported in 1996, 6 SCC 241. In this case, the Supreme Court has held that the rationale in making certain statement or fact admissible under Section 6 of the Evidence Act is on account of the spontaneity and immediacy of such statement or fact in relation to the facts in issue. But we must remember that this is necessary. Why? Because that such fact or statement must be part of the same transaction. Let us look into it from another angle. In other words, say such statement have been made contemporaneous with the acts which constitute the offence, or at least immediately thereafter. Why this is important? Because if there is an interval, however slight it may be sufficient for fabrication, and if it is sufficient for fabrication or concoction, then the statement is not part of the doctrine of res gestae. The next celebrated case of the Honorable Supreme Court of India on the doctrine of res gestae, which is quoted from the English judgment. I will be referring to the English court decision. It is reported as R.V. Lilium, 1896 to Queen Bench 167. In this case, what has happened? A statement was made by raped woman after the revestment was held to be not part of the res gestae. Why? Because on account of some interval of time lapsing between the act of rape and the making of the statement. Another case of the English law or the English common law is that was of the Privy Council, which was also referred by the Supreme Court of India while considering the extent to up to which this rule of res gestae can be allowed as an exemption to the inhibition against hearsay evidence. This is referred as Taper versus R, 1952 to all ER 447. In this case, the Privy Council held the rule that in a criminal trial, hearsay evidence is admissible if it forms part of res gestae. This is based on the proposition that human utterance is both a fact and a means of communication, and that human action may be so interwoven with words that the significance of the action cannot be understood without the correlative words, and the dissociation of the words from the action would impede the discovery of the truth. So we should remember that it is essential that the words sought to be proved by hearsay should be, if not absolutely contemporaneous with the action or event, at least so clearly associated with it that they are part of the things being done, and so an item or part of the real evidence and not merely a reported statement. This will be more clear in the subsequent judgment of the Supreme Court, which is reported in 1997, 4 SCC 161, paragraph 9. The name of the party is Ratan Singh versus State of Himachal Pradesh. In this decision, the Supreme Court examined the applicability of Section 6 of the Evidence Act to the statement of the deceased and held that the statement of one of the witness, Kanta Devi, which was admitted under Section 6 of the Evidence Act. Why? Because on account of his proximity of time to the act of murder. If you look at illustration A to Section 6, it makes it clear. What does that illustration A says? It says that A is accused of the murder of B by beating him. So what is I am talking about? I am saying that A is accused of the murder of B by beating him. Whatever was said or done by A or B or the bystanders at the beating, or so shortly before or after it as to form part of the section, is a relevant fact. Here, the act of the assailant intruding into the courtyard during the dead of the night and the victim's identification of the assailant, her pronouncement that the appellant was standing with a gun and is firing the gun at her, are all circumstances so intertwined with each other by proximity of time and space that the statement of the deceased became part of the same transaction. and therefore in this case the Supreme Court held that it is admissible under section 6 of the Evidence Act. The next leading case on the doctrine of res gestae is Malik versus State of Haryana, reported in 2011 7 SCC 130, paragraph number 37. In this case, the Supreme Court held or reiterated that section 6 of the Act has an exception to the general rule, whereunder hearsay evidence becomes admissible. Normally, oral evidence must be direct under section 6 of the Evidence Act, but under section 6, to bring hearsay evidence, the doctrine of res gestae has been referred. For bringing such hearsay evidence within the ambit of section 6, what is required? Number 1, it must be established that it is almost contemporaneous with the Act, number 1. And number 2, there could not be an interval which would allow fabrication or concoction. In other words, the statement said to be admitted as forming part of res gestae must have been made contemporaneously with the Act or immediately thereafter. In this case, what has happened, the prosecutrix admittedly had met her mother, Narayani, and sister soon after the occurrence. So, they could have been the best res gestae witnesses. Again, listen carefully. The prosecutrix had met her mother, Narayani, and sister soon after the occurrence. So, naturally, they could have been the best res gestae witnesses. But the prosecution still did not think it proper to get their statements recorded. As a result, the Supreme Court observed that this shows the negligent and casual manner in which the prosecution had conducted the investigation than the trial. And this lacuna has not been explained by the prosecution. To apply the doctrine of res gestae, the prosecution must complete the missing link. So, to prove beyond any shadow of doubt that it was the appellant who had committed the said offence or offences. And this case is also important from another point of view, because in this case, what the prosecution has done, it adopted a peculiar mode in the case. And what was that mode? The first statement of the prosecutrix was recorded under section 164 CRPC before the judicial magistrate first class. And only thereafter, her statement under section 161 CRPC was recorded. Normally, 161 CRPC statement are recorded by the police first, then 164 is recorded. But in this case, first 164 was recorded, then 161 was recorded. The Supreme Court held that the procedures that has been adopted shows that right from the beginning, the prosecution was doubtful of the trustworthiness of the prosecutrix. And precisely that was the reason that she was first sought to be bound by a statement under section 164 CRPC. Now let us understand what are the conditions necessary for a statement to be admissible under section 6 of the Evidence Act. A statement to be considered admissible within the ambit of section 6 of the Indian Evidence Act 1872 must satisfy certain conditions. And what are those conditions? Number 1, the statement should be a statement of fact and not an opinionated statement. So the first condition is that it should be a statement of fact and not an opinionated statement. Second condition is that the statement should be made by a participant to the transaction or a witness of the said transaction. So the statement must be made by the participant or a witness to the said transaction. The third condition is in regard to a bystander statement, which says that a bystander statement is admissible only if or she was present at the place of the commitment of the offence. If he was not present at the place of occurrence, then the third condition will not be fulfilled. The fourth condition is that in order to applicable to section 6, the statement should depict, describe, elaborate or explain the incident or the transaction in a similar way or manner. In this regard, kindly refer to one of the judgment of the Supreme Court, which is reported in 2013 12 SCC page 17, and the name of the party is Maharashtra versus Kamal Ahmed Mohammed. In this case, the Supreme Court held that it was satisfied that the confessional statements recorded by the accused. 3 accused whose confessional statements were recorded. One was Sadiq Israr Sheikh, number 2 was Arif Badruddin Sheikh, and number 3 was Ansar Ahmed Batsa. But the witnesses in that case did not satisfy the ingredients of the doctrine of res gestae incorporated in section 6 of the Evidence Act. Why the Supreme Court did not accept it? Because the statement made by these confessional statements was not contemporaneously arose with the bomb blast which had occurred at that point of time. And this was never the fact in issue. The confessional statement of the accused in that case was perceived by the Supreme Court that those confessional statements cannot be perceived to be part of the same fact in issue, because this statement always should be spontaneous reaction arising out of any incident. The statements under this case was made under such references which could not have been considered by the court. So look into the facts of this case, it will clear the concept of the res gestae. Generally, the evidence are brought under res gestae. Why? Because it is not capable of being brought under any other section of the Indian Evidence Act 1872. So what was the motive of the lawmakers? The motive of the lawmakers behind the introduction of the doctrine of res gestae was to avoid any sort of injustice in those cases, especially where the cases were dismissed and disposed of because of lack of evidence. If any statement is made which is not admissible under section 6 of the Indian Evidence Act 1872, what is the option left? In that case, it can be made admissible under section 157 of the Indian Evidence Act 1872 as corroborative evidence. When we discuss section 157 of the Indian Evidence Act 1872, we will discuss it later on, but we should remember at this stage that if particular any statement is not admissible under section 6 of the Indian Evidence Act 1872, it can still be admitted under section 157 of the Indian Evidence Act 1872 as corroborative evidence. With these words, I conclude my lecture for today and hope to see you soon again. Kindly subscribe to our channel and press on the bell icon so that we continue our endeavor to empower the younger members of the bar with various legal concepts from the practical point of view.